where we're going to be talking about the significance of the judiciary in upholding the rule of law, particularly the importance of an independent judiciary when internal structures fail. Jim and I are going to do this in a question and answer format, so we will go back and forth. And I thought what we really ought to do is to start with this question of the rule of law. It's been debated. It's the subject of books. It's been a debate since at least the time of Aristotle. The ABA has a rule of law program and a rule of law initiative. Jim, let's start here. What do we mean by the rule of law?
Well, it has many meanings, but we can boil it down for you. And thank you so much for tuning into this program. I think it's a very interesting subject matter. Probably the most common parlance of the word is when it's absent, as in years ago, the Marcos regime in the Philippines, there was no rule of law. It was all the will of the leader. And that's a very common use of the word, the absence of the rule of law. Then you get to these books, as you referred to, and there's a number of them. I couldn't possibly read them, but I can get the essence of it. For example, a philosopher by the name of Hayek has written a great deal on the rule of law, and he's not a lawyer, but it's a way of dignifying the question of the rule of law. When distilled to its essence, the rule of law means that each officer in the government, whether it's state or local or federal, is to follow the law. Now that implies that it's easy. And of course, as every lawyer knows, and all of you know, it's not easy. But the essence of it is that you have to follow the law. So when someone doesn't do that, for example, when someone is motivated by their own will, as though the law didn't exist, then that's an absence of the rule of law. And that's what we're going to talk about. There's a lot of aspects to it. And one of the things that would be very interesting is whether the concept of equality is really part of it. And I know you feel strongly about that, and I don't blame you. I agree with you.
So there, yeah, as you've said, there's so many different definitions. It's somewhat like the phrase justice. It's in the eye of the beholder to some extent. But among the people who have written about the rule of law, they talk about principles. Not only it should be about law and not about men, but about accountability under that law. And as you pointed out, I believe very strongly that this notion of equality, that there has to be fairness in the application of the law, that's a fundamental part of the rule of law. But the other one is also separation of powers in this country, that as in the Constitution, there's a separation of powers for decision making, legal certainty, and a way in which one avoids arbitrariness. So perhaps we should start by talking about that notion, the whole separation of powers, and what happens when that's undermined, if we want to talk about that piece of rule of law.
There's a lot to that, and the separation of powers didn't happen overnight. It took a couple of hundred years to get away from Henry VIII. Henry VIII was the personification of the application of the person's will over everybody else. He rejected Catholicism. He instituted the Protestant religion, and then he insisted that everybody follow it. Then, if they didn't follow it, he would do very bad things. Too bad to even mention here. Not much worse than just throwing people in the tower. So it was a slow progress, but by the time it got to Montesquieu, who was a landed high social person in France with some nobility to him, and with 11 words, that always impressed me. He had 11 words in his name. I mean, it's incredible. But he blossomed into a person that impressed the founders of this country greatly. And he impressed them with his theory, which John Locke also had a version of. They both had this theory that the way to solve these awful Henry VIII problems and kingly abuses was to have a separation of powers. And that brings us to the judiciary. The judiciary is not supposed to be intimidated. It's not supposed to be bullied. It's not supposed to be proclaimed by other office holders that what's going to happen or what they're going to do. They're supposed to be objective and independent. That's very, very important. So when we get to the separation of powers, we take it for granted at the state level, the local level, and so forth. You have the courts, you have the executive, and you have the legislature. And so when one person like the executive tries to dominate everybody else, the rule of law is at least injured, if not really hurt in a major way. The separation of powers, and I'll just mention this if I may, the present executive, the present president in this country has been defaming the court system, has been defaming specific judges, has been making what are clearly racial comments about judges, and all of that for the purpose of intimidation. We're not used to that. Any executive can have a bad day and complain about something. Eisenhower was sorry that he appointed Earl Warren and so forth, that kind of thing. But it's discreet and polite, and it's not really intended to intimidate anybody. So we have an issue on the rule of law brought about by the strength and the bullying of the executive.
So part of what we're talking about, I think, are the norms. Some people would say, well, the rule of law isn't just the law itself, but the norms that we've lived under that are now being challenged. As you point out, there's generally been respect among the branches of government. They can disagree with one another. The judges, can say what the law is and overrule legislation. They can talk about executive power. There's been a push and pull in terms of the encroachment of executive power versus the judicial power or legislative power. But at least there was always some sense of respect. And I think we've seen that undermined, which is why the question that we have on the agenda for today is what happens when the judiciary is under attack in this way, and the norms as well as the laws come under attack. So I'm wondering if you could talk about the role of the Attorney General in this. After all, William Barr has been accused of using the Justice Department as the personal lawyer of the president. There was a famous quote of Donald Trump saying, "Where's my Roy Cohn?" Meaning the person who personally would defend me, using the Justice Department as his personal lawyers. And there's been a great deal of protest by former Justice Department lawyers, by former Supreme Court clerks about many of the actions that William Barr has taken that really undermine the norms of what the Attorney General is supposed to do, but also undermine the law.
I served as a federal prosecutor for 5 years, and I loved the job. I loved holding my thumb up and saying, "Book them," but before I did that, I had independently, in most cases, thought about whether it was right to indict somebody or not by some standard. And that's very important. I have opposed Department of Justice lawyers for many, many years, and usually on a fairly friendly basis. And I respect their work. I know what the job is. And a politician has a completely different frame of reference. And a politician who's under investigation, as the president has been, has no business, none, in interfering, albeit in public, with the discrete discretion of the prosecutors. Mr. Barr, I think, has forfeited any idea that he is acting as an appropriate lawyer. It is hard to watch that on TV, because the effect of it is very good people who've been in the department for years are stepping aside, and they're not quiet about it. They've seen something that no other attorney general has really caused. There have Attorney General Mitchell was indicted, but that was for, as I recall, kind of money raising sort of thing. And so there's a serious problem. And you talk about norms. The norm that I was used to, and that most prosecutors are used to, is the White House has nothing to do with decisions about cases. They just should not intervene. And that's been violated all over the place, not just to intervene quietly, to talk to the attorney general or something, that's been done. But to blast now, today, to blast the attorney general because he won't indict the opponent, that is worthy of the most shoddy country that you can imagine. And that is very difficult on the judges. One of the judges, Judge Berman, was very specific. She said it sounds like intimidation. So that's leading, and we should talk about it. I'd be interested in your views as to where that goes from here, because it depends. But if a standard has been set that the president can intervene in criminal cases, we're in a lot of trouble.
Well, it's almost on a daily basis that people say we're in uncharted territory. There is a fundamental way in which the president seeks to undermine the very role of government, right? I mean, that's what's called for. Lack of respect for the government, lack of respect for Congress, lack of respect for judges. So, it is really unprecedented. And the question is, so what's to be done? I mean, obviously there's an election, and that's one overarching answer, but it does raise on a daily basis the question of, so what should judges do? I mean, what happens when the entire system is undermined in this fashion? That's what I think we should talk about for a bit. I mean, judges have a circumscribed role. In many ways, there are many judges who do not think they should be speaking out outside of their legal opinions in terms of answering what the role of the judiciary is. Others, of course, believe that they have an obligation to speak out and to educate the public about the role of the judiciary and the way in which government is undermined by the type of actions that we see by the attorney general. So, want to talk about that for a bit, Jim? The education piece.
Well, yes. The lawyers have a great obligation, and they have been fulfilling it, I think, around the country. A number of lawyers have gotten together. The former prosecutors in the Department of Justice, for example, I signed a petition with many others. And they have that obligation. It stems from the obligation lawyers have to defend the judiciary. If one judge is attacked, then the lawyers have an obligation to defend that judge if it can be done. And so here they have done their best. How much effect that has, because of the nature of the problem at the moment, the president just goes ahead and does whatever he wants to do. He acts. He doesn't just talk. He does talk, but he also acts. And the next thing you know, he's injured the system again. I think at some point today, I hope we talk about what the courts can do. And you raised a very important, serious question. Remember that the Court of Justice Berger had announced a unanimous decision producing President Nixon's tapes. That had nothing to do with the politics of who's president. That was quite a time. And I don't have much time to read past history and all that, but the little time that I have, I know the judges have risen to the occasion. So, for example, in Trump v. Voice, just decided in this last term, there was a criminal subpoena to the president. And the fact that it was criminal, I think, was quite important. And this court, with two Republican appointees by Trump and several other Republicans, decided 7-2 that the president had to respond to the subpoena. And it was telling, I thought, that Justice Roberts wrote a 9-paragraph statement. He joined the majority about how Thomas Jefferson had refused, and Justice Marshall, who was sitting as a trial judge in the trial of Aaron Burr, required that he respond to the subpoena. The most interesting part of that, I thought, was the concurring opinion by Justice Kavanaugh and Gorsuch, to the effect that no one is above the law. Now we're back to the rule of law. They wrote that in the opinion. Any sane person would see that that was a position, that they were staking out a position, the scope of which we don't know yet. But the court will have to defend itself and its reputation. I think Chief Justice Roberts has been doing that. And I think if you look at history, there have been times when the courts have used the independence of the judiciary, the separation of powers, in a very strong way. We can only hope that they will be able to do that in the months ahead to maintain the rule of law.
Well, as you point out, Chief Justice Roberts has often joined what's perceived to be the liberal wing of the court because of the need that he perceives for the legitimacy of the court. Some of it has to do with making sure that no one is above the law, which I think that they will continue to do as the judiciary stakes out its ground as compared with the executive and the led legislature. I mean, Donald Trump has just pushed things too far. So I think that will be true. However, there's concerns about even the legitimacy of the court these days, right? That it may be true that they will stake out a position to make sure that we don't have a king in this country, right? That everybody.
I just assume not.
You just assume not have a king. I know. Exactly.
Yeah.
But
Yeah.
now the court, look, the entire judiciary doesn't have, as often said, it doesn't have the power of the purse and it doesn't have the sword. All it has its own legitimacy, right? And if we want the culture, and that's what we're looking at now, is how does the culture accept the judiciary? It accepts it because it believes there is such a thing as the rule of law. It is not just the rule of men. It is not just politics. You know, it seems like now, even though with Justice Roberts having concern for legitimacy, we've moved into new territory, particularly with our latest Supreme Court soon-to-be appointee, that the public now may be losing its sense that the court really is about the rule of law. And it has much more to do with other factors, certainly like personal politics, personal predisposition. What about that when we look at rule of law?
Well, you know, I'm way out here in California, and so I have always approached Washington, D.C. with great caution, and I'm a little bit of a skeptic. And one of the groups that are nameless to me, I don't know who they are, kind of creepy crawly people actually, that prepare justices to get confirmed, okay? And they explain that you should just say nothing no matter what the question was. And that has worked on both sides. Both political sides have done it. But what interests me is sometimes an idea comes along and then it reaches the point of ridiculousness. For example, question to Judge Barrett, can the president continue the election? That was the point of bankruptcy, for the theory that all you have to do is just say nothing. When she said about my country, that the president can continue the election. She lost credibility with a lot of people, I think, because it becomes foolish. So, but the big problem is the executive claiming things about the judges. And, if you practice law for a long time, as you have and I have, you get used to judges who have certain attitudes and all of that, but they also mature. Judges mature. I've seen it where they see humanity coming before them every day, particularly in the trial courts, and they begin to understand things aren't quite what the doctrinaire feelings they had when they entered that. That doesn't always work, but sometimes it does. Here, we are now confronted with a situation, a threat that there will not be a peaceful transition. The president has put that on the table. I never thought I'd see that. Now, what is his plan? His plan is go to the Supreme Court with something and hope that Citizens United will have a rebirth. That was the 5-4 decision where the court intervened. My view is they didn't have to do that. There's other procedures to determine who's been elected, but they did. There's a marvelously detailed account in Justice O'Connor's biography about how she went through a lot of thinking, but she ended up being one of the 5 votes, and the result was the award of the presidency.
You're talking about Bush v. Gore, right?
Yeah, Bush v. Gore, and that's a precedent, isn't it? I mean, it's a precedent. You could say stare decisis or something.
Right. Well,
so I think we're on the edge of our seats with regard to whether that's going to be a replay. What do you think?
I agree. I mean, I've taught Bush v. Gore saying this doesn't stand for anything because they decided on equal protection grounds, and that's never been decided in any equal protection case. But that's what makes me think that people look at the court, the Supreme Court, and think it does not have legitimacy because what we're looking at is the 5-4, now maybe 6-3, Republicans versus Democrats. And when the public looks at the court, they don't see a neutral, impartial application of law. What they see is people looking at their personal philosophies, their predisposition, and deciding things based upon raw power. I mean, it's certainly true that Thomas is viewed that way, Alito is viewed that way, less so Kavanaugh and Gorsuch, and certainly not Roberts, but there is a concern that the court itself has lost legitimacy because of the actions it undertakes. It didn't need to decide Bush v. Gore at all. I mean, Citizens United, to which you refer, has really, I think, poisoned our country because it allows money to be used for any particular purpose, including putting people on the Supreme Court. I don't know if you saw the 30-minute speech that Sheldon Whitehouse gave during Amy Coney Barrett's
I did
campaign, and it was amazing. What he laid out was the monies that are used to put people on the court. And among the things he pointed out there are this, he calls them dark money because we don't know who's coming up with this money. But in many of these cases, there are amicus briefs filed. And amicus briefs generally you think are dispassionate from people who have a perspective. Well, it turns out in these cases that are predictably ones that's supported by the right wing in this country. 11 amicus briefs was filed, and every one of them was funded by the same group. One of them, in one case, it's called the Donors Trust, which he said is a gigantic identity scrubbing device for the right wing. And so here they're funding amicus briefs. Their money is behind ensuring that Federalist Society candidates are the ones who are getting on the court. When you look at voting rights cases like Shelby County, they decide cases like that, overturning long-standing precedent without any factual record. And so the court itself is standing its own precedent on its head in cases like that. And there's no wonder that there's a concern for legitimacy because it now looks like they're undermining it themselves by thinking they're going to overturn precedent, overturn Roe v. Wade, overturn the Affordable Care Act, overturn Obergefell. It's just, why do we have a court that is perceived in such a way?
The certainty with which certain people, probably in both parties, apply what I would call an ideology is disconcerting. And I think some of the wounds in the Supreme Court over years have been self-inflicted. The truth is, most of us, most lawyers, like a decision or we don't because we agree with it or we don't. We like this and we don't like that. And the courts are trying to deal with that as best they can. I don't think it's an easy job. But when they're always against employees, working people, as they were for 70 years, it was a 70-year period. There are a couple of recent books, one of which I read, about the last 50 years. That's a long time to always be against working people in a democracy. And you gave me a chance to mention, we say rule of law. Are we talking about the working person who drives an Uber car, in San Francisco? Is that what we're talking about? Because they probably won't be able to afford to go to court. They don't have, it's not just, the rule of law is not just substantive, it's procedural. So we still have 8 out of 10 people who can't afford a lawyer in the United States. And that goes to the heart of the legitimacy of the rule of law. You can't say there's a rule of law when you have people who have grievances that are, you can litigate, but they can't get to court. And there's thousands of them. And we should certainly at least mention that in passing. I know you have done a lot of work to help that problem over the years.
Yeah, and it's so funny that when we talk about rule of law, generally people look at the federal system. Right? That's what we've been talking about thus far.
Yeah,
Supreme
right.
Court in the rule of law. Lower federal courts, when federal courts, very brave judges in the South, Frank Johnson, judges like Damon Keith, judges over time who have stood up for equality and stood up for rights. We're looking at federal courts, but as you point out, I've been looking at state courts because this notion of the rule of law in state court, when you cannot afford to even get to court, when it's certainly true that studies done about many African Americans say they don't want to go to use the courts because their experience has been so many young men of color being put through the criminal justice system that they don't believe that there is a rule of law that will help them. There is just a system that actually punishes people, which is why sometimes we call this the criminal legal system instead of the criminal justice system. And so this whole notion of rule of law to me is a lot broader. One has to look at fairness and one has to look at equality and what are judges doing to increase the equality, to increase the fairness, right? So to me, the questions you're raising about money in the system is a big one. The extent to which anybody can afford to make themselves available to even go to a court to assert their rights. So
when you start to think of the groups and the areas of possible litigation and the lack of funding for it, you begin to think, in California, we have 2 million undocumented people. They have rights. I don't know what you heard on television, but out there in the audience, but they have rights. And there are asylum laws. The asylum laws are part of the rule of law. Another example is that money bills have to start in the Congress, in the House. That's where the bills start. And then when they are approved by the House and the Senate and they go to the president and they're signed, that's a very formal separation of powers example. And then when the president comes along on his own without asking anybody and takes all this money from pot A and puts it in pot B, you have a violation of the rule of law. And that's going on right now. And the Supreme Court just took that case. They took it yesterday. So what will the court do to preserve congressional prerogatives? Prerogative is a key word. It comes up in history. There used to be a lot of kingly prerogatives, but they're basically gone. What is the job of the president? How much is he entitled to do? And how does that affect the rule of law?
Well, what I think you just froze.
And think is who's going to stand up? Who's going to stand up to this guy? Who's going to stare him down? Who's going to tell him you can't do it? It's going to have to be the courts, and I'm afraid we are back to the federal courts. But I think that's got to be done. If it's not done, then this being a bipartisan panel, I'll be careful about what I say. But I will tell you, I've not been as worried about the rule of law in the United States during my lifetime, and I've practiced law 60 years. I've not seen the wildly out of control usurpation of congressional procedures and of judicial matters as we have at the moment.
And I think that that's true across the board, with rare exception among lawyers. I mean, even the lawyers who are Republicans who had actually voted for Trump and may vote for him again would recognize that a lot of the conduct is certainly not warranted, that a lot of the conduct may be unlawful. But the question I would raise is the court really going to do anything about this? Because what we've seen over time, and this was true under Bush, and it's true under, I'm not blaming Bush himself, but the court has moved much more toward a robust executive, right? That the executive has more power. They have less respect for the legislature, if you will. They are really undermining an administrative state, which is to say one of the ongoing concerns that I have of the court and the direction they're going in is saying that the executive can just overrule what administrative agencies do. It doesn't matter that we have administrative agencies, whether it be immigration, whether it be food and drug, whatever, issuing opinions, and they just get overruled by the court. So there is this notion ongoing of a very strong executive. It's certainly true with respect to war powers, right? I mean, we've seen the president engage in wars that are later deemed to be illegal. The courts do not step in because of things like political question or standing or whatever. But I'm really concerned now, particularly, I hope that the election is going to go in a different path and allowing Donald Trump to become president again. But even so, you're going to have a court that's going to allow the executive much more leeway compared to Congress, compared to states than it ever did before.
You know, you mentioned the powerful executive. There's a theory, and I wonder how many of our fellow citizens understand the theory or have even heard of it. It's called the unitary president. And it is discussed by law professors who exchange learned journals about it. But Trump is actually doing it. And in its worst, in the worst iteration, it holds that anything the president does is lawful. And there was a movie called Cheney, Cheney was the main character, and he gets all excited when he's told about this theory because it increases the power in the White House. Now, for those who are truly devoted, like Judge Barrett, to the idea that you just look at the statute, tell me where you see in the Constitution, started by some of the great progressives in the history of the world, that there's a unitary president and whatever he wants to do, he can do. They had just fought a war against the king who had mental issues. And there's no theory, legitimate theory of the unitary president, none. It's just a power grab. But there are those in the nation's capital who believe it. I'd like to have a program with one of them. I mean, I think that would be fun.
Well, there are numbers of academics, as you point out, who believe that. Many of them are also the people who espouse originalism as a way of interpreting the Constitution. And certainly, are there originalists, there are textualists, there are new textualists, there are various people who have looked at unitary president. It's a theory that Donald Trump put forward, as you recall, during the Mueller investigation, right? I mean, he put forward basically whatever he says, whatever the president does is legal, right? And many, some scholars at least, supported that when it came to what the president did vis-a-vis the actions that were investigated by Mueller. Those are among the same people who look at originalism as a theory. And you can say originally the Constitution said there was an executive, but as you point out, nowhere does it say that that person has unitary power over everything else. So we're now faced with, right, increased executive power, a theory of originalism by at least a number of the people on the court. And where that has led us is the encroachment upon civil rights, encroachment upon rights of workers, rights of women, all of the issues that people have fought for under a living constitution and a liberal constitution, liberal interpretation for many years, for the 50 years at least that you have practiced, as you point out. And the fear is, at least from the federal system, there's going to be much more limited availability of rights for the average person, which brings us back to, so what do we do? What do we do in terms of making sure that the rule of law is really about equality?
Well, I think judges just have to do the best they can do. But Judge Barrett suggested that you look at the words of the statute. So riddle me this, please. The Ninth Amendment of the Constitution says this. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. I like that. Now, many judges over the years have found ways to not deal with or grapple with the actual language there. But that's a good example. If I was on the court, which is at this point extremely unlikely, I would immediately raise a question about the Ninth Amendment to the Constitution, because I like the idea that we have a whole lot of rights here. I frankly have never understood the personal rewards to people, the feeling of accomplishment by spending their whole lives whittling down, and I'll give you one case as an example, whittling down the rights of the people of the country. There are cases where a right should not be recognized for some very good reason. There are conflicting, very often at Supreme Court level, there are two principles, and one of them has to be chosen. But the case I refer to is Lyons, decided in the early 1980s out of California, but at the US Supreme Court case. Mr. Lyons was injured, but he survived by a chokehold. And the case is a mess. It's all kinds of theories about mootness and so forth. But the heart of the ruling is, because he can't establish that he'll be subject to a chokehold again, he doesn't have standing. Well, standing is nice if you wanted to do something, but 16 men had been killed by chokeholds in Los Angeles. And that court turned that issue away.
Yes.
Now, was that John Dewey wrote on law? He wrote some stuff on law. He wanted to know whether it's good for a lot of people. That's what he wants to know. His work on schools was brilliant. He was a great thinker, okay? Now, what's so great about turning away somebody who's been subject to a chokehold, and what does that do to future generations like the one that we're in? I worked with police for a long time, 5 years. I know police, there's great policemen, they're wonderful detectives and others are terrific. And then there's some bad ones. Anybody who takes one side and not the other is I can't take them to be a serious person.
Well, there are numbers of cases, certainly in criminal procedure. When I teach criminal procedure, students are often aghast by the time they get to the end by the diminishing of the Fourth Amendment, the Sixth Amendment, the Fifth Amendment, whichever, and the way in which the court has used the power of the law, as you will, to deny people certain rights, which is why I keep going back to rule of law is equality. I mean, after all, if the legitimacy of the court depends upon what we would think of as a social contract with the public, meaning the public trusts the judiciary to rely on its expertise in rendering decisions that they think are carefully considered and that are fair and that are impartial in accordance with the rule of law. And if in fact the result is the denial of fundamental substantive rights, I think where we are is the diminishing of that social contract, which worries me greatly at the moment, frankly, that we're undermining all of our institutions. But as you say, it's up to lawyers and up to judges to ensure that we don't undermine the judiciary. And the question is how to do it. And Justice Marshall, he was teaching at Howard. And he went, well, I don't know if he was teaching, he was giving a speech to the lawyers at Howard. And he said, when you finish, I want you to use the law as a mean for social change. Equal justice under the law was written by white men, and he urged his students to make the country live up to his words, right? And so that's also part of the rule of law. I mean, it's funny. One of the interesting articles I've been reading lately, or articles, is about what do we mean by originalism, right? That why is it the 1787 Constitution only? I mean, that was actually a constitution written to ensure there was limited government because we've left England, et cetera. But then there was a civil war fought in this country, and there was Reconstruction, and there were a series of amendments. And one could say, go back to those amendments and say, originally, what was intended by those amendments? That's as much of it as an originalist view, if you will, as just looking at the 1787 Constitution. So that's all by way of saying that if you look at that, I mean, it's not what one thinks of as originalism, but people are looking to, this is Eric Foner, who's a historian among others, saying original, that's just as original in some ways. It's 1865 original, but why not look at that? If we're serious about rule of law as equality.
I don't know how you look at the founders of this country and not see them and say that you found something somewhere that you will now apply in 2020, because there never was a generation of Americans any more attuned to the idea that everything changes. They had just ended colonialism. They had just ended the domination of a king. How you look at that group, they knew. They had kept their journals are as learned as they can be. They knew things were changing all the time. They planned for that. They planned for change. So how you look at all that and come out with a sort of sterile system, I don't know. We should mention one other thing. May I mention one other thing? And I know we're going to take some questions.
Sure.
There's a whole other area. It's not quite as exciting as I think what we've been talking about, but that is the delegation of legal power to agencies. And that's a big issue. And our colleagues on the conservative side have reservations about agencies. And I must say there are times when I share those, sometimes having appeared for clients in front of agencies. But that's a big delegation. And that's also part of the rule of law, just for completeness sake. When someone goes into an agency and comes out with a ruling, that is the law. And the final point that I would like to mention on this subject is that going back to my friend Hayek, the philosopher, he had a great deal of skepticism about the ability of orders coming from the top, legal rulings and all of that. Having been in trial courts a lot, when someone loses a case and there's not going to be an appeal, when they walk out of the courthouse, that is the rule of law. And so everything must be done to get the very best people to be judges, because no case can decide the details of a local case. And that issue of where law really is, the best quote I ever saw was from Sherlock Holmes in The Red Hand, and he and Watson had just kind of seen a case that didn't come out the right way, and he said, "Justice is what we seek. Law is what we have to live with." And between justice, as you mentioned it, and law, there are very often gaps, but they are applied very often in the trial courts of the United States, of which there are hundreds, if not thousands.
And state court judges as well. I mean, most of what goes on for people in the legal system happens in state court. Very few people end up in federal courts. And so when we look at our justice system, when we look at the judiciary, I think it's important to focus upon what is going on in those trial courts and appellate courts in the states. Before I go into some of the questions, I just want to raise one other point that's akin to your Ninth Amendment point. My mentor in law school was a professor named Arthur Kenoy. He's the one who argued the Nixon tapes issue that you're talking about. I remember him saying he stood up before the Supreme Court expecting lots of questions. There wasn't one question. And it was a 9-0 opinion. In any event, he always said there aren't 3 branches of government. There are 4 branches of government. And he would rely on Jefferson and say, and the 4th branch of government is the people. And the rights are reserved to the people. And I think akin to your point about the Ninth Amendment is we really do need to get people to understand their role within the legal system, that it's not just those people over there, it's not just the judges and the lawyers, but we somehow need to empower the average citizen to be part and parcel of our legal system.
Can I tell you something to answer your question about, what are we going to do? I'll tell you what's going to happen. If the rule of law continues to be assaulted, the lawyers in this country are going to fight like hell, and people better pay attention to it. It will happen. And what is it I know? Not a lot, really. I know lawyers, okay? And they love a good fight, and they will not quit.
I think the same thing, Jim. And I was very encouraged by you and the other hundreds of former Justice Department lawyers who have stood up to bar. 1,600 lawyers called for Barr's resignation after that staged photo op in Lafayette Park where they sprayed all those protesters with bullets. So yes, I agree that lawyers have a great role to play in upholding the rule of law. So one of the questions we're asked as a question is, so what range of improvements can be made to better enforce the rule of law, including for the judiciary? And so why don't we just start with lawyers, because lawyers will speak out. Lawyers do speak out. It is important in my mind that lawyers stand up for what judges have done, because we don't allow judges, or we say judges should not be defending their decisions in public. It's up to lawyers to do that piece. How about that one?
Well, it is, first of all, I agree with that. It is up to lawyers. And, the irony of the muck that we are now in is that if you like civil liberties, you couldn't be living at a better time, okay? The issues are everywhere. We can't even keep track of them because the one that was so hot yesterday has been replaced by an additional one today. That's a serious problem. So the lawyers will be good, but the courts are going to have to do and forgive the vagueness of this idea. They're going to have to do the right thing. that Supreme Court, if it wants to retain its credibility, will have to hold together the important nuances of the United States Constitution and the separation of powers. They'll have to do it. And my guess is they will. Contrary to the hunches, we are inundated with the idea that these are all Trump's people and all of that. This may be utopian idealism on my part. Maybe it is. But I think the judges on that court, when confronted with a usurpation of congressional authorities or judicial matters for that matter, will rise to the occasion. I have to believe that. I have to believe that.
I wish I believed. I think, I think there's some nuance in the sense that they won't say that the king is above the law. I mean, we will have some way to rein in an executive. But I think overall, in terms of the kinds of civil rights issues we're talking about, they will continue to undermine class actions. They will continue to undermine the ability of the average person to bring a case. They will continue to undermine a woman's right to choose. They will continue to undermine voting rights. So on and so forth. I'm not very sanguine about
I agree with you on those issues.
Yeah. So, but I do think that in terms of what can be done, I think there needs, at a state court level, there needs to be advocacy. So, for instance, in the criminal justice system, that there's money for criminal defendants. I mean, the judiciary ought to speak up on that issue. I mean, that doesn't interfere with the work that they do. Lawyers need to speak up. And there are a variety of ways in which lawyers can ensure that we will have more monies available for poor people. So that's one. I mean, all of the various ways in which, whether it be housing court or immigration, we don't have lawyers, and we need lawyers for people. So that's one a very significant way that we can increase respect for the rule of law, the actual rule of law. We talk a lot about procedural rights, which is fine, which is being respectful to people who show up in your court, making sure people understand their rights. But when it really comes to the substantive rights, to making sure that a person has a lawyer to help them, we're not doing as well. And it's really incumbent upon the judiciary to go to the legislature, if you will. I mean, some state court judges do that and advocate for more monies. The lawyers need to do the same. So I think that's a key part of assuring that we have the rule of law.
Well, your state of New York has, through the chief judge of several years ago, was a real leader, and went to Albany and got at one point, I think, $70 million for lawyers.
Right.
The resistance to that is not just theoretical. If a person does not have a lawyer, for example, when you're foreclosing on their house, it's a lot easier. And there were circumstances where people lost their houses in about 10 years ago because they didn't have a lawyer. They lost their house. Or in some states, you can lose custody of a child without a lawyer. It does happen. So there are all these fundamental. So from that perspective, when we say the rule of law is the state can't take your child without a lawyer. It's and I'm not saying this casually. It's a violation of substantive due process. It's and as a person who has represented a lot of people, it's a disgrace. It's terrible. And I've been in courts and I've seen the people being evicted and all that kind of thing. It's terrible.
And lawyers can speak out. I mean, I think lawyers have a lot of power in that regard. And so, for instance, your law firm did a lot of pro bono work. You did a lot of pro bono work over the years, and spoke out about it. And spoke out about the rights of refugees. Spoke out about religion. Spoke out about the issues that mattered. And I think large law firms, in particular, can have a great deal of force in the culture in terms of making change. So merely for any law students who are listening, merely because you decide you're going to go off and work for a firm to pay back your loans does not mean that you can't speak out on major issues. There's a lot of.
If you go to the right firm, and there are many, it can be a bully pulpit. And you can undertake that issue of reform that you really care about. And then you do your, what I call money bono, lots of money bono, and you do your pro bono.
Right. And I also think that judges are a bit too timid in terms of speaking out. There are some judges over time who have spoken out on critical issues. Judge Judith Kay in New York. Historically, there's many judges who have spoken out about civil rights, right? And now we have Judge Rakoff, and we have Judge Gleason. We have a number of judges, or certainly that I know of in the federal bench, who have spoken out about various issues. They can do that. It doesn't necessarily mean that it's going to influence a case that they will decide. They need to do that carefully, of course. But I think it's incumbent upon them. They have the respect of the public, and I think they have an obligation to ensure that there's greater equality as part of rule of law. Jim?
Yeah, you're in and out there a little bit.
No.
I look to the chief without optimism, but Chief Justice Roberts, he's in, for a person who has verbally talked about his legacy, and he should, he's Chief Justice of the United States. This is the time now. This is it. You don't pick your time to live, but here it is. And if the court is to be saved, and I use that term advisedly, it'll have to be Roberts that leads people to that solution. And you're right, I'm not talking about the right of workers and all those kind of conservative issues, but I am talking about whether the president can be contained within constitutional limits.
And the final piece we have to go soon, I know, is I wanted to talk about Judge Katzmann in the Second Circuit, who was very concerned about the lack of understanding of the role of the courts, and has started a project called Justice for All, where they actually have judges and lawyers, a major project, go out and talk to community groups, talk to high schools, bring them to courts, so that there is a robust understanding of the role of the judiciary and the separation of powers and the role of government. And I think lawyers and judges can do more of that as well. So we haven't gotten to the other question. How do lawyers push back against and challenge originalism? It's a longer discussion, but among the things I would say is because there's a lot of inconsistency, if you will, about originalists, there's new theories called the new textualists, of people who are looking to the text, but also to the consequences of interpreting laws in certain ways. And I actually think we'll see some version of what we've had so far, a living constitution, come back. They just won't call it that. They'll call
There's
it.
There's a book by Mr. Fish, Professor Fish, I guess he is, that he has a literary degree and he has a law degree. And the book is 500 pages, and it talks about how to interpret written literary subjects and the law. And it's as deep as you want it to be.
So there's lots out there challenging originalism. I would ask I would encourage the questioner to look at the new textualists, because I think that's the direction that things are moving in. Originalists aren't really just originalists, because frankly, the original Constitution was founded on slavery, and they really can't get over that. They just can't get beyond that. They have to make up ways to get over that. So, you know, it is not just slavery.
It's not they that have to get over it. I mean, it's not an intellectual thing.
Exactly. It is the foundation of this country. So when you think of that's the original country, the original Constitution was 3/5 a person, right? You can't, the idea that you're looking to that to interpret modern reality, frankly, is so disturbing that it's hard to even know what to say about it.
John Locke benefited by his investment in a slavery company. John Locke, of all the liberty philosophers in the world.
So it's good that there are no statues to him anywhere local. Anyway, it's really delightful to be on a program, Jim. Go back and forth, have this conversation.
Absolutely, anytime.
Thank you.
Yep.